Good evening, everyone. I, Saquib Rahman, Senior Lecturer at the Department of Law, North-South University, would like to welcome you all to our webinar today. It would be an absolute pleasure on our part to be able to listen to Professor Amy Gajda, who has very kindly made the time to talk on academic freedom of students, faculty, and universities in the present era. Before we request Professor Gajda to start, I would like to bring to the notice of the listeners that the chat box is open and that they may address any questions there in the box. The audience is requested to please keep their microphones off at all times. And lastly, I would like to extend my thanks on behalf of the Department of Law to all of you present here today. Now, regarding our guest speaker, Professor Gajda, Tulane Law School's class of 1937 Professor of Law, is a journalist turned lawyer. She is recognized internationally for her expertise in privacy, media law, torts, and the law of higher education. Her scholarship explores the tensions between social regulation and the First Amendment values, particularly the shifting boundaries of press freedoms and rising public anxieties about the erosion of privacy. Professor Gajda's latest book, Seek the Height, The Tangled History of the Right of Privacy, will be published by Viking in 2022. Harvard University Press published two of her earlier books. Her scholarly articles have appeared in journals including the American Historical Review, the California Law Review, the Georgia Law Review, the Indiana Law Journal, and the Washington Law Review. Professor Gajda is the winner of both the Felix Frankfurt Award for Distinguished Teaching, Tulane Law School's highest teaching honor, and the Tulane President's Award for Excellence in Teaching, Tulane University's highest teaching honor. She has been a visiting professor at Brooklyn Law School and at several universities in Europe and Asia, teaching privacy law and media law. Now, before we start with Professor Gajda, I would like to request Professor Rizwanul Islam, Chair of the Department of Law at North-South University, for his introductory remarks.
Thank you very much, Saquib. Good morning to our esteemed guest, Professor Amy Gajda. Good morning or good afternoon or good evening to our students, listeners, wherever you may be. It is an utmost pleasure for me to welcome Professor Gajda and also to have the audience with us this evening. I must admit that I'm a big fan of some of Professor Gajda's scholarship, which I have been privileged to read. I've used the word privilege because those were real treats and I thoroughly enjoyed some of her works. The talk that she is going to deliver today, the issue of academic freedom in contemporary era, I think in some of her scholarship, she has very eloquently shown how the unfettered academic freedom that academic institutions and we academics used to enjoy is somewhat changing. Traditionally, the courts and the broader society, I think it is fair to say, had a lot of deference to academic freedom. That what happens within the academic matters, that is a matter for the academics. However, with the changing nature of our universities, not only in private universities, but also in publicly run institutions, the way universities run is creating some questions in the mind of many beyond the academia that how much academic freedom should be respected. I would not say that the courts are always intruding on academic matters, but I think it would be a fair statement to say, as Professor Gajda has shown in some of her works, that courts are no longer as differential to academic freedom as they have been. And among the greater public, there is some sort of question mark about the role that academics play and academic institutions play. And there is perhaps a greater question or willingness to view academic freedom with the same degree of deference that used to be the case. So what does all this mean for academia and for academic institutions? I look forward to Professor Gajda's talk this evening, and I also look forward to your questions. Thank you all.
Thank you both for such wonderfully kind introductions. I am absolutely delighted to be here, and I very much look forward to your questions, both as we go after this talk, but then also I should mention that if you have questions beyond that, I would very much appreciate getting emails from you, and so you should feel free to continue the dialogue here by email or otherwise. What I want to do, I'm going to talk for about 30 minutes, and then I'll take those questions. And I want to start by saying that the reason why I became very interested in the notion of academic freedom is not only because I live it every day in the classroom. When I make decisions about how to teach certain subjects, I'm making those decisions based on my right to academic freedom in the classroom, promised me by contract, and also promised by many professors by the Constitution of the United States, that academic freedom springs from the First Amendment. The First Amendment's promise of speech and press and expression freedoms. The reason why I'm particularly interested in this is because many people in the United States believe, as you all recognize, that that academic freedom is all powerful. And so that therefore they can say whatever as a professor, they can say whatever they want in a classroom and not be punished in some way for it. But this is not what my research has shown. It's not true in privacy situations, which is my other area that I focus my research on. And it's not true in the classroom either. Academic freedom may come from the First Amendment, from the speech freedom, the expression freedoms there. But the way my own academic freedom is impacted by the academic freedom of students as well. And so I'm going to talk about that later on, as you'll see. I have the freedom to try to teach the way I think students will best understand, but the students in my classroom also have a constitutional freedom to learn. And so therefore, you can imagine if there's some sort of uncomfortable discussion in the classroom, I have to be conscious not only of my academic freedom to teach the subject in a certain way, but also my students' academic freedom to learn in a way that enables them to, truly understand things without reacting in a certain way, and more about that later. So mostly I study those times, as you heard, in which courts in the United States have pushed back against academic freedom in some way, the times they pushed back, especially against professors' academic freedom, First Amendment rights to speak and to teach how they want in the classroom, and to write about subjects in a way that they want to write about as well. So I'm first going to talk about two main things, and they're interrelated, as you'll see. First, I'll start by explaining tenure in the United States. I assume many of you know this already. Its importance in the United States, the reason why it has changed the way some universities are behaving. They're becoming more business-like, as you heard, and courts are responding negatively against that. And second, I'll explain about this concept of academic freedom and its connection to tenure, and why it's a crucial part, as I say, not only for not only for professors in the classroom, but also for students in the classroom. So, so let me explain first why I'm the class of 1937 professor of law. Some of my students think that's because I was born in 1937, or because I graduated from law school in 1937, but that's not correct. The reason why I'm called this is because after I got tenure at my university, there are levels of professorships. And one of them is a professorship called the class of 1937 professor of law. And it's named in honor of the class of 1937 at Tulane University Law School. And what I did in order to earn this professorship is that once I got tenure, I then continued to produce scholarship. You know, I continued to teach, of course, but teaching is far less important to these sorts of professorships. My title gives me a little extra boost on campus, not so much a monetary boost, but a you know, it gives me recognition on campus that I'm more than just a professor. I hold a professorship in addition. There are chairs above me, there are university professorships above me, but it puts people on notice that, yeah, I've done work beyond tenure that the university believes should give me some sort of recognition on campus. Again, a little bit of a boost. I wanted to talk with you just a little bit about my career so that you understand the importance of tenure to someone like me, and also generally how it happens. Many of you may know this already, but certainly not my story. I started my career as a visiting professor at the University of Illinois. And at the university, my husband is also a professor, so we're you know, we're a couple teaching together. And I started my career at the University of Illinois, and there I was hired as a visiting assistant professor. A visiting assistant professor, generally on campus, on any campus, means that you do not have a permanent position at that campus. Instead, what you have is year-to-year contracts. And so you can not perform in any particular year and be fired. Also, that title anticipates only a 3-year contract extension. So a series of 1-year contracts for 3 years, and then you're out. And the reason why is because some courts in the United States have found that if a person stays on a campus and continues teaching beyond 3 years, that they are presumed a permanent member of the faculty. Some courts have actually said that they're presumed on the tenure track. And so therefore, the rules on campus are very clear: 3 years and you're out. For me, what happened was I got a tenure track offer from another university. And what I did then was I said, hey, if you want me to stay here at the University of Illinois, you're going to have to give me a tenure track position. And so that's what they did. They gave me a tenure track position at the University of Illinois. And at that moment, I then had to begin my scholarship. I had to begin being focused even more on my teaching, and then finally also on service. And I'll explain each of those things in just a moment. The reason why going on tenure track is so incredibly exciting for people is because in the United States, if you get tenure because of academic freedom and other rights, it is basically impossible, nearly impossible, for a university to fire you. And so therefore, I've worked at law schools before where people who are in their 80s are still teaching. And they're doing so because they're very capable teachers. But I know that in a number of other countries, there is a mandatory retirement age. That's not so in the United States. And so therefore, I can conceivably continue on and teach into my 90s without being fired once I have tenure. So it is the promise, in effect, of a lifetime job. When you're given or on the tenure track in the United States, there are these three areas that matter. And what you do ultimately is you put together a portfolio. It's a very secretive process in which peer scholars from other law schools across the United States look at your portfolio and judge you of being worthy of tenure. So from the very moment you go on the tenure track, you recognize in effect that you have 7 years to prove yourself. The most important part of that portfolio is your scholarship. And so often this is so much more important than any other. And students especially are very surprised to hear this. I've heard the suggestion that 85% of the importance of a portfolio, of a tenure portfolio, is scholarship, that teaching is 10% and that service is 5%. And so even though students may think of teaching as the most important thing, certainly scholarship is most important in terms of tenure. That would include law review articles if one is a law professor. That would include books and otherwise. Teaching, not so important, as many students, of course, know, and will be able to tell you with great passion. They have some teachers who should not be teaching in the classroom because the students just simply don't learn anything from particular professors. But because those professors are performing so well in scholarship, and because of academic freedom protections, et cetera, those teachers, then those professors will not be fired by the university. The third part of the portfolio is service. All that means is serving on committees and that sort of thing. So that's sort of a look then at tenure. Again, one once gets tenure, the only way that one can be fired because of academic freedom, because of the way we treat tenure as a property right. The only way that people can get fired is because of horrible criminal behavior. So truly horrible criminal behavior, sexual harassment of students, maybe even repeated sexual harassment of students, some other sort of really heinous behavior with students. But universities are very hesitant to attempt to fire someone who has tenure and who has that sort of lifetime job. In comparison, people who do not have tenure, so people like me who started off as a visiting assistant professor, there's greater ability to fire those people because their contracts are generally year to year. And what's been very interesting is because of this shift in universities toward a more business approach, some universities toward a more business approach in deciding issues involving teaching, students, et cetera. Tenure track positions like mine are becoming more and more difficult to get. And so therefore, many more positions are teaching positions, are adjunct positions, or or are staff positions in which people teach as well. And that makes good business sense for the university, because why not pay $30,000 a year for someone who teaches the same classes, but can be let go after 1 year if finances don't make sense anymore, versus paying, a tenured professor. This is far from what I make, but some professors can make $200,000 or more in the United States, way more than that. Some of them can make, and so therefore it just makes sense to hire someone for $30,000 instead. And so those business decisions are being made. That's why positions like mine, tenured positions, are becoming increasingly rare generally in colleges and universities. So now here is how academic freedom plays a role, and you understand that already a little bit. If you ask a professor in the United States what academic freedom means, they will definitely tell you, I have academic freedom to research what I want and to teach my classes how I want. That's what a lot of professors believe, but as I suggested at the beginning, it's not as clear, certainly anymore, that's right. This is the way the American Federation of Teachers describes academic freedom. Again, think about the focus very much here on academic freedom of the professor. Academic freedom is the right of faculty members to determine without outside interference the college curriculum, course content, teaching, student evaluation, and the conduct of scholarly inquiry. So again, very much focused on, my decision to write the books I want, my decision to teach my classes in the way I want. But students then, of great surprise to some professors, actually also have their own academic freedom. So academic freedom has been a part of the culture in the United States, and certainly a part of law for a very long time. In 1915, so more than 100 years ago, a group that called itself the American Association of University Professors created these guidelines, and they used language like this. Academic freedom means the academic freedom of the teacher. And this is 1915, more than 100 years ago. It promises freedom of inquiry, freedom of research, freedom of teaching, freedom of action and extra mural utterances, which simply means my giving a talk like this one today. It became a constitutional right in 1967 when the United States suggested that academic freedom was in fact a special concern of the First Amendment. So suddenly academic freedom is vaulted into this high level constitutional protection. And what that generally means today is that scholarship in public discussions in classrooms, as I've said, there is some level of First Amendment protection for the teacher. If my university, for example, wanted to fire me for saying that some universities had turned more business-like, they would not be able to. My contract contemplates academic freedom here, and so courts uphold that contract. I only say that, and this is a little bit confusing because Tulane University is a private university. If I still worked for the University of Illinois, it would be a constitutional promise and a contractual promise as well. But here by contract, I have the First Amendment, related ability to speak how I want. And by the way, I don't feel that way about Tulane. Tulane has made some very surprising decisions that I think a business would not have made. And just as one example, last term during this pandemic, we were testing students, undergraduate students, and we have thousands of them, 3 times per week for COVID. And each test was said to cost about $50. So that's a really surprising decision made by the university. Again, not a business decision, because certainly that was a very poor business decision, but one that was meant to protect students from the pandemic. Courts have moved, as we've said, against some sort of academic freedom. They become far more skeptical. But before they did that, and certainly after this decision from the United States Supreme Court that looks at that vaulted academic freedom into this constitutional right. Courts would generally say that they were hands off. They showed colleges and universities extreme deference for their decisions, and they would hesitate to second guess any of those decisions. Here's a quote from an expert. Back then, courts were reluctant to interfere with academic evaluations. Judges would and should show, or should, other judges said, should show extreme deference to decisions in higher education about how things should be taught and more. So that was the lay of the land in the past. It was pretty easy to argue that academic freedom protected professors. It was an important shield in hand with tenure that protected certainly people like me. But some things have changed, as you know, from the tone of this discussion. Certainly those of us who are tenured still have great protection, but there are fewer of us on campuses throughout the United States. And certainly a lot of tenured professors should not be here because of tenure and because of concerns about academic freedom. So there's real pushback now in the culture of the United States against academic freedom and against professors who are tenured like me. And that includes the very well-educated here. So, so there were some comments. I wrote this book a number of years ago now, and the book was reviewed in the New York Times. So, probably the most elite newspaper for the most elite readers in the United States. I argued in the book that there'd been a dangerous eroding of academic freedom in the minds of the public and also in the minds of judges, and that could well work to end academic freedom as we know it in the United States. And so interestingly, these very well-educated readers of the New York Times then responded with comments in this way. Academics have cushy jobs that they don't perform. Universities use bait and switch tactics to lure students. Tenure is a joke. Used car salesmen have better standards than do academics. So this real pushback even among the elite in the United States. And so even though we have, this tenure, even though we have this academic freedom, certainly the culture has changed. And there's a greater aggressiveness than within the culture, but then also in other ways as well. And I think one of the most important recognitions today, as courts are pushing back against this notion of academic freedom, and certainly as culture and even some universities push back against the notion of tenure as being all powerful and something that should, where someone should be able to continue without further evaluation of their scholarship and their teaching into their 90s. One of the clashes, as I suggested before, is with students' rights to academic freedom. And so as I suggested, students have academic freedom. I can decide how to teach my higher education law class. For example, I get to decide what assignments I'm going to give them, what the syllabus looks like, how I'm going to grade those students. But because there is this academic freedom, constitutional academic freedom of students on the other side, they have that academic freedom to learn as well. And so today, this academic freedom of students has risen up arguably as this strongish counterbalance to the academic freedom of professors in some cases. Why then courts are in the United States recognizing that, we shouldn't just defer to people like me. Maybe I didn't even take, which is true. Maybe I didn't even ever take a class on how to teach a class. Maybe I just get the sense of how students, best learn, which is true. I've, done so for more than 20 years now. But courts are, starting to recognize, why should I be given special deference for how I teach certain students if they say they're not learning well from me? So you get this pushback in court cases, and I just want to give you 3 quick examples. A student in Washington, D.C. sued the university after the student received grades that the student didn't like. And so brought a lawsuit against the professor and against the university. The court sided with the student, at least initially, and suggested that maybe, that certainly a professor should be given deference, but not always. And so, wanted to take a deep dive then into this particular professor's grade of this particular student. Another ultimately decided with the university and with the professor, but not after the court took a very hard look at projects the professor had assigned, the class syllabus and what it promised, because a lot of courts have suggested that a syllabus is actually a contract between the professor and the student, and that therefore, if this professor does not follow the syllabus, they can be sued for breach of contract. What grades the professor had given other students and the students' own grades. So, think about that. Courts are really looking very hard at these areas that used to be protected by academic freedom. Another student convinced a court that a professor was acting negligently when that professor returned exams in a certain way. And so the argument was by giving access to other by giving other students access to these exams, then these other students could take another student's exam and mark it up in a way that would harm that other student. So there have been a number of examples like this. So again, the argument goes that as colleges and universities have become more business-like and making these business decisions regarding adjuncts and otherwise, that courts are then more willing to say, okay, we're going to treat you as a business. And just like we would feel willing to go and look into an employee's file and figure out if you'd fired that employee for the right reasons, we're going to look into a student's file as well and see if maybe you didn't grade that student in a way that student didn't deserve. Again, can't tell you how deeply unusual this is based on academic freedom principles in the United States traditionally. So academic freedom is certainly changing in the United States. And as another indication of this, some universities are in fact moving toward post-tenure review. For me, once I got tenure, nobody looked at my teaching anymore. Nobody is really, they do a little bit, you get raises based on this. So every year, maybe we get more raises, more money, and things like that. But my tenure will never be revoked. If I decide not to write anything anymore, which I can't imagine, but if I decide that, it doesn't matter because I have tenure and there's no post-tenure review. Some universities have moved toward that now. Some professors are finding it more difficult to argue that they have the right to teach in a certain way. And I'll just give you one quick example, which I'm horrified at, but shows you, I think, how strongly professors were protected in court because of constitutional academic freedom promises. One professor decided that he was going to teach a first year writing course to undergraduate students at a university and use sexual innuendo throughout because he felt that the students would learn about these principles in a better way if he did that. Students complained. They said, we don't want to learn about how to write an essay using sexual innuendo. That makes us very uncomfortable. And the court back then, many, many years ago, decided that the professor had the right to teach that writing class that way. That is not something that a court would decide today because, that students, because that rising, I would predict, of student courts recognition, increasing recognition of students' right to learn. And so courts are in fact reining in professors and universities in cases where they wouldn't have years ago. So I wanted to end with a quick story, and that is one that just happened to me this year. So I also teach torts here, which is civil wrongs, and that includes torts like battery. And what that means is, as you may know, battery is a wrongful contact with another person. And so it's basically a wrongful contact, something like a punch. What I like to show my students every year is a video that's available on YouTube. And it shows someone in an elevator dressed up in a certain way. And what he does is he waits in the elevator until someone gets on, the doors close, and he suddenly begins fake punching the person. So he begins acting as though he's going to fight the person in some way. And most of the people are just sort of, horrified and back off. And he immediately says, oh, this is just a joke. And so we talk in my class about, about battery, about his, if there's been any sort of contact, what other sort of torts might be involved in this elevator. I said this year, take a look at the woman in the elevator. So there's this young woman who's in the elevator, and she is very clearly very distressed by this behavior. She thinks that she's on the elevator with someone who is going to batter her, if not worse. And you can see the fear in her eyes. I talked a little bit with my students, admittedly, about how I had the academic freedom to show them this video, because I think it's a really important, way to look at the law and to look at how we define the law of battery and the other torts that we were talking about. This year, one of my students raised his hand and said, with good humor, so he meant it in good humor, that maybe I shouldn't have used the video in that way. That maybe the video was disturbing to some people in the classroom, and that maybe either I shouldn't have shown the video at all, or that maybe I should have warned the students about the video that they were supposed to see. So that just happened this year. And I think what that says is three things. First, the student suggested in the classroom that, maybe he and others in that classroom had that academic freedom to learn. And so, he had the confidence to suggest that maybe the way I was teaching it, wasn't the best way. And again, he meant this in good humor. I know that, he thinks I'm a decent professor, but it shows greater confidence then on the part of students to push back against the way professors teach certain courses. Second, it shows that some motivated student, might actually get out there and sue for such a thing. I don't think they would win based on my academic freedom. I have very clear reasons why I use this video. To me, this video is not certainly highly offensive or disturbing in any way. But I have used disturbing videos in the past. And what I do is I always alert my students, the class before, I send them emails through the week, and I send them emails the day of the class, just to let them know if you don't want to attend, I'm happy to talk with you about it later on. But it shows you then that students who do want to sue can sue for such a thing. Third, it shows how dynamic I think academic freedom is in the United States. How, I have my academic freedom to teach. The university has also some academic freedom as well, but how students have academic freedom to learn, and therefore, how all these three different, sometimes uniting, sometimes clashing, then subjects can come together. So if I had to guess what the future holds, I would guess three things. Number one, academic freedom of the professor is going to continue to erode, especially in the area of classroom teaching. I just think courts and judges, I should say, are just much more amenable to deciding what goes on in the classroom, and don't give the deference that they used to. Second, because of that confidence, I think that colleges and universities are going to recognize that, why not then do post-tenure review? Because they won't be as afraid to make the argument to a court that post-tenure review is in fact, important for their reasons. And so I would suggest that post-tenure review will then also become increasingly common in the next few years. And third, that maybe freedom to learn, that students, the academic freedom of students, will in fact become an interest that continues to grow, and will then push up against the academic freedom of the professors that used to be, all powerful to many extents. So we'll see if I'm right. And I'd be delighted if you, got in touch with me over the course of the next few years, and I can report back to you and let you know if I am or otherwise. So thanks so much for listening, and I'd be delighted to take any questions that anyone has.
Thank you very much, Professor. Professor, we do have certain questions. Whenever you're ready, I'd like to convey each one of the questions to you one by one.
Sure.
All right, Professor, the first question is from our chair of the Department of Law, Professor Rizwan. He says, as I understand it, Professor Gajda has argued that academics should be more engaged with the greater public. Does she think that the academics are doing this enough, or more appropriately, is there enough incentives for them?
That's a really wonderful question. I mean, certainly the question of incentives is interesting, because remember how I suggested that the most important thing is scholarship. The most important thing is the written word. That sort of more public engagement is considered a part of service. And so remember that I suggested that service was the least important of the tenure portfolio. I have argued before that if we want to protect academic freedom, one way to do that is by giving greater weight to that sort of more public engagement, and giving credit even in situations where law professors who generally don't engage with the public much, might get additional scholarship credit for doing so. If that happened more, I think that courts would be more amenable to finding academic freedom in cases involving professors and even within the university. That is, courts saw greater community engagement, that courts, meaning judges, would respond in a more supportive way to arguments of academic freedom on the parts of professors, and then also on the parts of universities, because they'd be seen less as businesses and more as, public outreach institutions, which is the way they were perceived in the past.
Thank you very much, Professor. Here's our second question. In terms of academic freedom, do you think how you would compare the US with, how do you think you'd compare the US with other advanced economies?
So I have not studied, I've not studied things internationally, so I'm not the best person to ask about this. But one of the things that I find most intriguing is this cap on teaching. And so therefore, when one turns 65 in a number of countries, one has to stop teaching. And this is in, countries, I believe Germany is one of them, and I could be wrong about that. But think about the difference between that and then how then the faculty changes much more commonly than in these other countries as opposed to in the United States, where because of tenure, people can keep on teaching for a very, very long time. So I do think that that's one area that that is of particular interest to me, and it would be very interesting to take a look at that dynamic and how that might play out. Certainly another very important part of academic freedom in the United States is the First Amendment-based idea. And so therefore, when I say academic freedom, I have the full weight of the Constitution and the First Amendment behind me. And certainly that is very different from other countries that don't have that same protection, certainly not exclusive protection, but very strong protection for freedom of speech and for freedom of expression and freedom, of publishing and of the press in that way.
Thank you very much, Professor. Professor, we have a question from Professor Nazmul Nahar. She's a professor of engineering at North South University, and here it goes. So we are talking about academic freedom of individual faculty, students, and universities. But at the end of the day, our objective is to take a holistic approach and help the students take the 4-year journey through a well-thought curriculum to become a wholesome person. If academic freedom affects that process, do we still advocate for academic freedom the way it is now, or do we want to restrict it? So
the first thing I'll say is I very much appreciate that definition, and certainly, certainly I find that definition very, very inspiring. This holistic approach to the student and how the student learns, and I think that's critically important, as you must understand, to certainly being a professor. And I certainly think it's also why most people become professors, to enable students in that way, to see students grow, to teach them in a way that makes them excited about learning, and that causes them to find their path in life, and makes them happy for hopefully the remainder of their life as they find their career. I don't think, however, based on the way most portfolios are looked at in the United States in terms of tenure, that is the focus, because as I suggested, 85% of the of that tenure portfolio is publication. And in fact, when I won my teaching awards, you heard that I've won teaching awards here at Tulane. I had one of my friends at another school say to me, "You know what a teaching award means? It means you're not publishing enough." And so if that's sort of if that's the mantra of the academy, you can see why courts might be tending away from that, and why courts might be finding colleges and universities more like businesses that are much more worried about their rankings. And rankings are oftentimes based not on student evaluations, but on scholarship. And the greater impact then on academic freedom and how courts might respond to it. Again, I think certainly I can tell you that most of my colleagues here at the law school, we're known for being good teachers. But I do know of a number of other schools across the United States where the mantra really is, if you win a teaching award, that's a very bad thing because you should have been writing instead. But I find that, as I say, I find that question itself very inspiring.
Thank you very much, Professor. Here's another question. Regarding non-tenured academics, do more reputed universities, fewer of them, or universities, or is it more or less the same in all universities?
So I didn't, can you repeat the question, please? I'm not sure. I know it's involving non-tenured
It does
people, right?
involve non-tenured academics. I think the question, there's a typing mistake here, but I think what the person tried to say is regarding non-tenured, is it only the reputed universities who have fear of them, or in general, I mean, when it comes to all universities, is the number more or less?
So I think that the number is increasing generally. And so generally it's increasing because it makes good economic sense. It makes good economic sense to hire someone for $30,000 a year or less. Maybe the person is given $10,000 per course. And think of that. A tenured professor may only have to teach 2 courses a year. And if that tenured professor, if you could hire someone for $20,000 a year versus $200,000 a year, it makes business sense to hire those untenured people who are teaching courses. And it's a very sad situation when we think about, that holistic approach to students and student understanding and the role we play in that. These untenured untenured teachers very often will teach at different universities. And so there was this really poignant story in the Washington Post a few years ago now that talked about this teacher, this college teacher who would drive, I think, to 3 different schools and teach at 3 different schools. And I can't remember how many courses that person was teaching, but think about students there. I mean, students just aren't getting that same level then of engagement outside the classroom with those professors as well. So again, I think that's one of the reasons why we have this pushback by courts.
Thank you very much, Professor. Here's our next question. Would it be fair to say that more lawsuit-prone universities are somewhat changing the uninhibited academic dialogue in the classroom?
So what I find intriguing about that question is I don't know what more lawsuit-prone universities might be. Now, I think that for-profit universities might be more lawsuit prone. But, with students, I think, becoming more emboldened, I don't know if we could really say what sort of university is not going to be lawsuit prone under certain circumstances, especially because again, at least for me, and this goes back to the other question, I think if I can have a relationship with students inside the classroom and outside the classroom, and if students trust me, I think they're going to give me a lot of leeway. But if I'm not fully there for them, you know, it does, just being a lawyer, I understand that, you know, there might be that sort of real pushback, like, who is this person in the classroom? You know, why didn't she follow the syllabus? Maybe I should sue for breach of contract. And so therefore you can imagine, you know, the students who also are beginning to think much more of colleges and universities as being, you know, a business. It's a business decision. Where am I going to go to school? You know, what class am I going to take? What does that syllabus look like? What is therefore that contract between me and the professor? And the more at arm's length the professor is with that student, the more likely it is that, you know, the student could think about suing in a way that a student wouldn't have in the past. And so I do think that there are more colleges and universities that may be more university, or maybe more lawsuit prone, especially those that are for profit, because they don't necessarily have that same ability to have the relationships that we do on you know, on a campus like we have, for example, here, you know, being physically present in a classroom, for example. But I'm worried enough to suggest that, you know, I think all colleges and universities can be sued in such a way. I know a few years ago, Yale was sued, just as one example, for negligence in, you know, an intriguing way in a lawsuit brought by a student. So, so it's not just the for-profits that have to worry.
Thank you very much. Professor, here's our next question. If an academic says, why should I care about what non-experts or non-students say about academia, what would you tell
So
them?
if an academic said, what do I care about what non-academics say?
Non-experts or non-students say about academia, what would you tell her?
So one of the things I would, you know, try to explain to the person is I think there's a deep misunderstanding out there between what is really happening on campus and what isn't. And so therefore, when you get these comments in the New York Times, for example, that that say things like, you know, academics have cushy jobs that they don't perform. Universities use bait and switch tactics to lure students. Tenure is a joke. Used car people have better standards. What I would really like to do is engage with that person and, you know, ask them, you know, why do you say such a thing? You know, what causes you to say such a thing? Certainly, I could say such a thing based on my own experience as an undergraduate. You know, I could definitely make a lot of these same arguments. And I think I felt that way when I was an undergraduate to some extent. But I think that what's the most important thing that colleges and universities and professors can do is really engage with those people on the outside. And that includes judges, to better explain what colleges and universities do, you know, what the good ones do, what the good professors do, and how we really do try to reach people, and how we do really care about teaching. And so that's basically what I would attempt to do if someone, you know, gave me their impression of higher education. I think it's very worthwhile to you know, respect that, but then also, you know, really try to go deeper into why that person suggests what he or she says based on then you know, their lived experience and then what I know, you know, being deeply immersed in now a number of colleges and universities and how they work.
Thank you very much, Professor. Here is our last question. We actually received a lot more, but we had to choose from
oh,
them,
sure. No, I appreciate it. And as I say, if anyone would also like to email me, you know, a question, I'd be happy to engage by email.
That's very kind of you, Professor. Professor, here's our last question now. So what about the relation between academic colleagues in more litigation-prone academia. Would you please share your insights on this?
Sure. So one very interesting that I didn't really touch on here because it doesn't really have that much to do with academic freedom, but because these tenure track positions are so difficult to get, and because they are basically a lifetime promise of a job, what the other way that colleges and universities have changed over the course of the past few decades is that now professors who are denied tenure will sue for tenure denial. And so it used to be, a number of decades ago now, what professors would do is they would leave and they would not sue, they would leave the place where they didn't get tenure, and they would go to a different college or university and get tenure there, attempt to get tenure there, attempt to get a new job there. And that was possible because there were a lot more tenure track jobs out there. Today, because there aren't those tenure track jobs available, it makes good litigation sense, plaintiffs' attorneys would say, to sue to try to get that tenure track position that had been possible actually given to them by a court. And the important thing to note here is that there is an awful lot of racism. There's an awful lot of sexism in academia still. And so some people don't get here because of racist reasons, because of sexist reasons, because of pushback against the particular area that they're researching, when academic freedom should in fact protect this. But it's not just those people who sue. So it's people who sue more generally. If someone, for example, I think that there was a claim a few years back by a professor against a professor who'd written a negative review of an academic piece, because that professor who sued recognized that, I have to sue because that's an important part of my tenure portfolio. And if I don't get tenure, I have to make the argument, that actually that was defamatory in some way. And so I think that that's a really important part of what's happening now too, that if somebody doesn't get tenure, certainly there are very, very good, important reasons to sue. But those lawsuits happen a lot more often than they used to, including for reasons outside of, discrimination in some way, or, some other way that we would classically say, well, that plaintiff has a really good reason to bring the lawsuit. And again, the motivation here is because these jobs are in fact pretty cushy, and we do in fact have the potential to be in this position for an entire lifetime. And so that's why there is more litigation when someone doesn't get tenure, when that tenure vote doesn't go as the person hoped.
Professor Gajda, thank you very much. You've answered the questions wonderfully, and I am sure all of the audience, they loved your talk, and of course the question and answer session, which was very interesting. For those of you who might have missed any part of Professor Gajda's talk, you'd be happy to know that we will be uploading this particular webinar in our YouTube channel. Professor Gajda, thank you very much again. If there's anything that you want to say to the audience.
Other than it's been a real pleasure and an honor as well, and as I say, I'd be delighted to engage with anyone who would like to in the future. So thank you very, very much for having me. It's, as I say, it's been a real honor and a real pleasure. Thank you.
Thank you very much, Professor.
Thank you very much for your time.
Okay, thank you for the invitation. I loved it. Thank you, everybody. Bye-bye.